So Bob, our seller, right? He's a good guy, right? Not didn't do anything wrong, but Bob goes and gets in a car accident, right? And the person he hits in the car sues him and gets $1 million judgment against him. That other car driver can, once they get the judgment, can record what's called an abstract, and it affects any property that Bob owns in the county it's recorded in.
Hi, everybody. Jose Luis Morales here. Welcome back to another episode of the Morales Group Show. Today, we have a repeat guest. The name is Jennifer Felten. She did a previous episode with us on partition actions, and today she is going to be educating us on wraparound mortgages. I've been getting a lot of questions about wraparound mortgages with interest rates going up. In no way, shape, or form, I am an expert on this, but I'm in a very similar position to the viewers today, where I just want to learn what wraparound mortgages are, how they work, what are the pros and cons, and I couldn't think of anybody better than Jennifer Felten to be on the show. So thank you very much, Jennifer, and welcome back to the show. How are you?
I'm good. Glad to be here, Jose.
Good. So for our viewers that don't know who you are, who is Jennifer Felten and how did you get involved in this world of real estate law?
In my first life, I was actually an escrow officer. So I did transactional real estate for 15 years. I transitioned into law, went to law school, got my degree, and passed the bar. And I have been practicing as an attorney now for 15 years, solely in the real estate space. So I own a real estate law firm, and we do all kinds of things real estate, including preparing documents like a wraparound mortgage.
That's awesome. It's funny how you say in my first life. In my first life, I was a cowboy boot salesman. That was my first life.
Perfect.
Good. All right. So for our viewers that don't know what a wraparound mortgage is, what is a wraparound mortgage? How does it work? And what are some examples of maybe wraparound mortgage transactions?
This is something that comes about when we are in a marketplace where interest rates are rising. Okay. So, we all lived through 2 to 3% mortgages for the last couple of years, right?
Mhm.
And now we've got 6 and 7% mortgages, right? And so if I'm a buyer and I'm going to buy in, my price to buy and my monthly payments are going to be significantly higher at 7% than at 2%, right? And so the result is that buyers want to buy in and keep the interest rate that their seller had, right? Because their sellers have these great loans at these great lower interest rates. So the idea is the buyer buys and keeps the seller's interest rate. It's easier said than done, though, right? Theory great,
Mhm.
practicality. The result is that the sale happens and the existing loan remains on the property, with the seller then lending, being the lender to the borrower or buyer for either additional money, for additional interest rate, for taxes and insurance. All kinds of different things can be built into a wraparound because it is a privately negotiated deal. But the idea is to allow the parties to keep the benefit of the existing interest rate while allowing for the sale of the property to a new owner. And they're triggered by all kinds of different reasons. A seller needs to sell, maybe, right? And is
Mhm.
struggling to get the price they want. We have buyers who don't qualify or don't qualify at the current rate, but potentially would have qualified before. And so it allows for this outside the box, right, type of financing for a real estate purchase.
How is this different from assuming the loan? Like, so for example, like I know that there's some loans that are assumable. I think
Right.
that there's VA loans that are assumable. In some cases, some other loans may be assumable. How is this different than that?
Right. So in a loan assumption, if we're doing it properly, we're putting the lender on notice, right? And so we're reaching out to the lender. We're saying, hi, I'm Bob. I own a property. My buddy Jack wants to buy the property. Can we get Jack to take over and now be the borrower under my loan, right? At the good lower interest rate. Traditional financing, Fannie, Freddie Mac, right? Any of the things that we're going to see for traditional financing are not assumable. They have what's called a due on sale clause in the loan documents. So they're not going to allow for a voluntary assumption of the loan. There are exceptions. VA and FHA loans are both assumable. So those are built into those lending programs. but you have to notify the lender. They have to approve it, and it's all done through that process. Understand VA, and so VA's veterans, right? FHA, Federal Housing Administration, both of those types of loans are guaranteed by the government. Okay, so the government guarantees those loans for a certain type of borrower, right? For VA veterans, for FHA low income, which low income is pretty, like, I think the VA limit in Ventura County is over 900,000. So low income is a very broad term, but people who qualify for FHA. So with government loans, and I'll just say this up front, don't ever try to do a wrap around a VA or an FHA loan. They are assumable, so you can negotiate with the lender. If you don't qualify, you don't qualify. But if you do them and you don't notify the lender, it's a federal crime because they're guaranteed by the government. So it's loan fraud. So those I would not ever do without doing an assumption where the lender is on notice. With wraps, the lender is it's loans that aren't assumable, right? Is when we're doing assumptions. So the loan itself does not have a feature that would allow it, but they want to do it anyway. So we're doing it in contravention of the terms of the original loan.
If somebody wants to find out if their loan is assumable, they would just check the loan documents that they sign. And in the loan documents, when you sign at escrow, it basically outlines all of the terms of the loan, and it'll let you know if it's assumable or not assumable. Now, here's one thing that you said that was interesting because it kind of leads to creativity. And I think that these wraparound mortgages can be extremely creative, which is a good thing, but then it's also a potential bad thing as well too. You said that a wraparound mortgage can be negotiated for additional money, additional rate, or just additional anything, or less, even less rate, less whatever. Can you give us maybe an example of what you mean by that, or can you elaborate a little bit further on that?
Yeah, so I'll make up a scenario so you can kind of get a sense of how this works. So we got Bob again, right? He's got this house. He bought it for $1 million. He owes 750, right? So he's got a 2% loan, right? And Jack's coming around. Jack, if he gets a loan, is going to have a 7% loan. So if Jack bought it, his payment is going to be double what Bob's payment is on this house, right? Based upon that change in interest for the same $750,000, right? So Bob and Jack sit down and they say, okay, let's do this. I want to take advantage. So Jack wants to take advantage of the lower interest rate. Bob wants to get the house sold, right? He may be able to, it may be about price. It may be about timing. There might be a prepayment penalty. So we're waiting out time for a prepayment penalty. Maybe Bob doesn't want to realize all of the income for the sale of the property. So if he sells it to Jack, it's called an installment sale where he only gets the difference over time. So he's not realizing all the income. So there's all kinds of reasons why Bob and Jack might want to do this. But so we decide we want to do this. Well, does Jack need to borrow the whole 250? Right? Does he need money? Does he have $250,000 to cover Bob's equity? If not, maybe Bob lends him $850,000. And so the wrap loan is for more than the original loan, right? Or maybe, Jack only needs half and he only borrows 500 and they pay down 250 on the existing loan. Whether it has to do with rate, payments, timing, right? Maybe Jack has a bankruptcy that's going to go off his record in a year and then he'll be able to refi and he'll be fine, right? So all of these are the things that are going to be triggers for why people want to do this, why they wouldn't qualify, or the benefits of a traditional sale don't work. And so between them, they will figure out what deal works for them in any given transaction.
So basically, if Bob had the 2% mortgage, you're basically saying that Bob can basically say, hey, look, I'll let you take over my mortgage. You can continue making payments on that. But instead of the 2%, I'm going to charge you 4%, which is better than the 7% that is out in the marketplace right now. And basically, Bob would be able to keep the difference between the 2% that his bank is and then the 4%, that would be like a residual stream of income that Bob could have. In addition, you're saying that if Bob has $250,000 in equity and Jack doesn't have the $250,000 to put down, Bob can say, hey, only give me 150 and I'll finance the other $100,000. So you'll be able to
Exactly.
take over my loan of 750 and an additional $100,000 that I will finance for you, basically.
Correct. Right. So seller financing is not an unusual thing, right? Seller carrying money, and especially, lenders, traditional lenders want to lend 80%. So it's not
Mhm.
uncommon for the seller to carry all or part of the difference, right? So it's really still following that model, just, depending upon what circumstances we're in any particular negotiation.
How do you actually do a wraparound mortgage? Like, what happens in the background? Like, okay, so we went over a scenario of what people see on the front end, but how does it work on the back end, basically, of it?
So understand, we haven't done this in years because we haven't needed to, right? Rates were so low that wrapping wasn't a thing. And we go through cycles, right, of this. So the last cycle when we did this was like 10, 12 years ago. So we haven't done this in a while. So everybody's trying to figure out, if we're going to do it, how do we do it? So the first question is, are we going to complete the sale, right? As far as go through title and escrow, there are title companies who will insure a wraparound, and there are escrow companies who will process a wraparound. And we can go through a traditional, we enter into a residential purchase agreement, we do the seller financing addendum to document the wrap, and we do a traditional escrow. At close of escrow, the deed records transferring title to the buyer, and we record the wraparound, which is in a second position on title after the existing loan, right? So we've done a traditional escrow. We've done all the things that we would do. Are property taxes paid up to date? Are there any other judgments or liens on title, right? We complete the full sale. So that is one way to process a wraparound transaction. The concern with doing that is that recording of the deed and then now the subsequent deed of trust is going to put the lender at least on constructive notice of the sale. And if we're doing this because there's a due on sale clause, it could trigger the lender to initiate foreclosure proceedings as a result of a breach of the terms of the loan transaction. 10, 15 years ago when we did this, that was still the case. But from a practical standpoint, it wasn't common for the lenders to do that. And as long as they were getting their payment, as a general rule, they would be okay. The issue is we're in a very different lending market, and we're in a very different technology environment. So before, monitoring title was more challenging 10, 15 years ago. Now you can set notices, right? Like if something records, you can be put on notice. So the lenders are gonna, in my opinion, the lenders are gonna know this has happened. And then they're going to have to make a business decision of whether to allow it or not. So that was very different the last time we went through this. So if that's our fear, right? If we're worried about the lender calling the loan, then we can do a wrap without recording. Okay, so the parties will still negotiate the agreement. There'll be a deed prepared and a deed of trust prepared, but none of it will get recorded, right? So we don't have recording, we don't have title insurance. It's all held in escrow pending either completion or a breach, which would trigger activity. So it depends on who you're worried about more, right? Because if I'm a buyer and I've done this, the seller's still on title to the property. So what if the seller gets in trouble and they get a lien? That lien's going to attach to the property, and now the seller lien is my problem as the buyer who has bought the property, right? So it's all about trust and figuring out who you trust the most, who you feel the risk more comfortable with, on how
Yeah.
you want to move forward on the transaction. What if the buyer or the seller change their mind and we haven't recorded anything, right? It's going to be much harder to try and enforce your agreement versus if it's recorded and documented. But as soon as we record it, we've put the lender on notice and we have the risk of foreclosure.
So there's really two ways of doing it. It's kind of like you either record it or you don't record it. And it's
Mhm.
just a matter of who you fear less. If it's not recorded, does that mean that the old seller can almost just like sell the property without even notifying the buyer of the property, like almost sell it under him? Then you wake up one day, there's a new owner on title. That new owner never found out about it because it wasn't recorded. Can that actually happen in practicality, or
It
is it
could
just me
happen.
going extremely to the
No,
right?
it could happen. But there are ways to mitigate that. So, so same kind of thing. If there's another concept in the law called a contract for sale, right, where you enter into a contract and you actually pay a certain amount over a certain amount of time, and then title transfers at the end. So we record what's called a memorandum. So and so you could do that with this situation. You could record a memorandum of agreement to put people on notice that there is some sort of agreement between the buyer and the seller. That in and of itself would not trigger the due on sale clause, but it would make it public record, which would mean any buyer who bought would be subject to the claim of the buyer, because that's recording is all about notice, right? So we could record something aside from the deed and deed of trust that would at least impart constructive notice to mitigate the risk of that. But my fear is much more of a judgment creditor or something like that that's going to attach to the property because the seller's still on title. So you got to really trust your seller that they're a good guy, right? And they're not going to have an issue. There's all of this. So this whole agreement is about trust, right? So even if we do this, so assuming we move forward, either way, the buyer is going to make their monthly payments to the seller, and the seller is going to pay the underlying lender. So there's a lot of trust that has to go on, that the buyer believes the seller is going to make the payments, right? And there are ways to mitigate that. You can actually record a request for notice from the lender of payments. But as soon as you do that, now you've given the lender another notice. The property has been sold, and it gives them another reason to potentially trigger the due on sale clause, right?
What was that called? A request for what?
It's a request for notice. And there's multiple different types of notices that you can request as someone who has an interest in a real property.
How does the memorandum differ from recording the deed of trust, and why doesn't that trigger it? And
Right.
does the memorandum make it impossible almost for them to sell it with traditional title insurance? I would imagine that the title insurance would be like, oh, look, there's this memorandum here. This memorandum actually states that the property sold. Oh, I'm sorry, we can't insure this, which would make it less likely to be able to sell. Is that the case?
Correct. So the memorandum, it depends on the scope. So we do memorandums for all kinds of things. We can do a memorandum of lease. We can do a memorandum when there's a letter of intent, right? We can do a memorandum when there's a first right of refusal. Any of these potential impacts on title to real estate can be recorded as a memorandum. The purpose of recording it, again, is to just put people on notice that they need to ask more questions, right? They need to go to the people who are party to the memorandum and confirm what they have and don't have to mitigate their risk. So a memorandum is going to show up on a preliminary title report as an exception item, right? So when we get a preliminary title report, the things that are listed on there are the things the title company is not going to insure, right? So it's not the good things, it's the bad things, right? That the prelim lists. And then as the buyer, you say, I don't want to take responsibility for A, B, C, right? Whatever it is. And those are the things that escrow clears before we close, right? So a memorandum would be on that list. It would be that you'd pull it up, you'd find out who's involved, and you'd ask questions if you're doing it right to figure out what's going on. So it would make it uninsurable to a new buyer without resolution of that memorandum, unless they agreed to take it subject to that memorandum, which would be
Weird.
ill-advised.
Not only that, but most lenders, or at least the Fannie and Freddie, likely wouldn't finance with a
Oh,
memorandum like that in place. And the memorandum
correct.
would basically say, I'm not familiar with memorandum. This is like completely new to me, which the
Yep.
idea of it is brilliant. Or the concept behind it is like, oh man, like you could actually use a memorandum for a lot of different things. Like you said, even a letter of intent. Hey, there's a letter of intent already in place, almost just like to not secure an interest, but to give notice to everybody. What is in a wraparound mortgage? What does a memorandum typically say, or what does it look like?
The memorandum would say there's an agreement between these parties. The scope is very, this is not a mandated form, right? So it doesn't have like a standard format. So you can put as much or as little information in the memorandum as you choose to. It is just going to be a trigger that the parties to the memorandum would need to be notified and the memorandum removed from title before you can move forward. So like I said, a lease, a first right of refusal, all these different things can put you on notice. And then it means you got to go back to that person and clear their claim before you close or risk their claim. Same concept as what's a lis pendens, right? If you're suing someone and you're suing and that property is impacted, the attorney is going to record a lis pendens, which is going to show up in a preliminary title report as a notice of a lawsuit. That lawsuit will need to be dealt with before you transfer, or you take title subject to whatever happens in the lawsuit, right? Same concept.
You said that the main concern with the non-recording of the, even if you record a memorandum, if you don't transfer the deed of trust, is judgment to creditors.
Yeah.
For our viewers that don't know what that means, can you give us maybe a couple of examples of that?
So Bob, our seller, right? He's a good guy, right? Didn't do anything wrong, but Bob goes and gets in a car accident, right? And the person he hits in the car sues him and gets $1 million judgment against him. That other car driver can, once they get the judgment, can record what's called an abstract, and it affects any property that Bob owns in the county it's recorded in. So Bob did nothing intentional, was never trying to, hurt Jack or cause him any issues. But this car accident has now put him, as a debtor, and now that could impact because the claim by the person in the car accident would be higher than Jack's claim against that property, and so that would have to be paid off before Jack could get clean title to the property.
Which a lot of people don't think about it. So let's say that they go with the opposite route. Let's say that they're like, well, look, that's too much of a risk for me. I don't want to not record it because there's that risk of this person potentially getting in some sort of legal complication. Even if he's a good person, there's always that risk. And then in that scenario, it almost like let's say that you have 500,000 in equity, but it's under somebody else's name, then that could wipe out the equity that you have. Not only that, but a lot of people don't realize this, that when you put people on title, that risk exists. So I know people that put like their kids on title. I know people
Yes.
that have put like a family member on title. They don't realize that when you put somebody else on title, not only do they have the right to make decisions on the property, but now you risk the risk of them potentially getting some sort of judgment, which could wipe out the equity completely. So putting somebody
Correct.
on title is, or having somebody on title is something that a lot of people don't think about, but it's really, really important.
Correct. It's just something that we went through with the foreclosure meltdown, 20 years ago, right? Was people would put other people on title with the idea of stopping a foreclosure. And it often worked. It often did stop the foreclosure from moving forward. But I now have these people and there was these fraudulent foreclosure rescue companies doing this stuff, right? So I now have people coming to me because they've got these people still on title now, right? They've worked out their loan, they're back current, but they can't refi or sell because they've got these people on title. Sometimes the people don't even exist. They put fake names. So you got to go to court and get those people off a title, which it's really hard to sue someone who doesn't exist, right? So it's a real challenge. So it is definitely, managing your title is a huge deal. There's no doubt. And
Very,
this is
very
one of
important.
those situations where that's part of the consideration of this whole process.
The other thing that you said is that you got to trust the seller, because as a buyer, you're making payment to the seller and the seller's making the payment to the bank. Is there a way to get a servicer instead where you can make the payment to the servicer? And are there right and wrong ways to handle that?
A servicer would be a viable option and not a bad idea, as long as everybody's in agreement. The issue is there's multiple things, right? So we just want to, again, we're trying to mitigate the lender knowing what's going on, right? While still, managing risk and mitigating that on the other side. So think about hazard insurance, right? So if I now go on title, I'm now the person listed on the hazard insurance. Well, the lender's looking for the old seller on the hazard insurance, right? So we have to leave the seller and the buyer on the insurance. So the seller is going to be an additional insured under the homeowner's policy in order to not trigger the insurance clause on the existing loan, right? So there's layers and layers when we do this of all the different pieces we have to think about, right? So if we transfer title and record, we're also going to get reassessed. So we're going to get a new property tax reassessment. If we have impounds and all of a sudden the lender sees that the property taxes went up significantly, that's going to be a red flag. What happened to trigger reassessment? New insurance. What happened to change the insurance, right? Everything we do can trigger notice to the lender and give more reasons for them to potentially foreclose.
If you wanted to not allow the other owner on title or stay on title, but you also wanted to reduce the risk of the lender finding out that you've sold the property via a wraparound mortgage, what is the best way to actually structure a deal like that? Is it for the seller to make payments? What's the best way to handle the insurance as well too? What are like best practices? Obviously, nothing is 100% secure, but like there's certain things that I would imagine that you've seen that are less likely to trigger the lender, or maybe not even that. What are don'ts? Even if we look at it like, what are no-nos? Like, don't do this because this is going to trigger the lender. We could even
Right.
approach it from that perspective.
Well, I mean, if any of this could trigger the lender, um, it, if you're going to do this, that just is part of the risk, and you got to be prepared that that could happen. The current foreclosure process in California is really slow, so that's a good thing from that perspective. It's 210 days best case scenario for a lender to foreclose in California. So if we do get a notice from the lender and they start the process, you at least have some time to try and work through an action plan to move forward, right? And decide what you want to do. Maybe we unwind the transaction, right? Though that's probably not going to solve the triggering of the due on sale clause, but the seller may be in a better position to renegotiate or get a new loan versus the buyer. You know, a good quality buyer isn't buying in this style, right? So the seller may still be in a better position to deal with the loan, and we unwind the transaction. And those are, and again, these can be things that get negotiated if the lender does trigger the due on sale clause. We are going to do A, B, or C, right? You can say, if this happens, this is how we plan to deal with it, right? So always being proactive is a positive, right? Like a prenup, or a operating agreement for an LLC, a tenancy in common agreement if we're buying property together. The more that you plan at the start for the risks, the better to mitigate if something happens, because we're all in agreement right now, right? We've come up with this great idea, we're doing this wraparound, and everybody's on the same page. 6 months from now, if we're in foreclosure, the seller hasn't performed or the buyer hasn't performed, trying to get agreement becomes significantly more challenging.
What are some of
Right.
those things? And I love the idea of thinking worst case scenario. Hey, look, let's say that the lender calls the loan. Like this
Yep.
is ABC, what we're going to do. What are some of the other things that should be outlined in the wraparound mortgage agreement? So obviously
Yep.
one of them is what happens if the lender calls the loan. What are some of the other things that you would make sure that you would put in those documents or try to negotiate in those documents up front? Because like you said, it's easier to get it done up front than to get it done if the seller sells and he's in Mexico already and just zero cell phone reception or whatever.
First is, how long are we going to be in this arrangement? So a wrap should not have an unlimited time frame, right? It should be a short-term loan, because the longer it goes, the more risk everybody has. So a wrap is going to be a balloon from that perspective, right? So 1, 2, 3 years, and again, maybe like my example, right? The bankruptcy comes off in a year, then we set the timeline a year and a half or 2 years out, right? Or whatever the factors that have resulted in this. Often the seller wants to do this to mitigate their capital gains on the sale of the property, because the seller is carrying paper, right? So it's a seller carryback. The seller is not realizing the full value of the sale, so they're not going to have the same taxable impact. Their receipt of payment over time from the buyer is what's called an installment sale, right? And so there may be a timeline for that, which means the seller will realize the gain over a broader period of time, which can put them in a lower tax bracket, right? All these kinds of factors go into it. So that may be a reason why a seller wants to do this, right? But maybe the seller needs that to be 3 years. So they may put a prepayment penalty on it so that the buyer can't pay them off sooner, or they have risk, right? Because their whole plan was to give them time and not have to realize all these capital gains. So again, we have to look at the factors of why we're doing it, and then put in the plans for dealing with if things change.
And then I think you said in terms of time frame, 1 to 3 years. What's the longest you've kind of seen in these wraparound mortgages? Do you ever see somebody say, "Hey, I've got 25 years left on my loan. Let's just do it for the full 25 years"?
It doesn't make sense. I mean, people do crazy things. but but that honestly is not in either party's best interest. I would highly, if they're getting consultation, they're being told that's a bad plan, right? Whatever the factors that are leading to this, they should be resolved within a few years. If they're not going to be, then we got way bigger risk, right? If our buyers got bad credit and they're going to continue to have bad credit, like people with bad credit don't pay their mortgages, right? So, that's not a good plan unless there is a plan for resolving whatever the triggers are for this. The risk is not worth the reward, in my humble opinion.
So I wanted to go over 2 different scenarios for you. And I overheard this in a different conversation with another real estate agent that's a friend. He said that there was a situation where they didn't record, or they recorded the deed, but the old owner stayed on title on a very small portion of the title. And that made it so that they could still have a portion of the insurance under their name, and it would reduce the risk of the due on sale clause. But that if they did stay on title, there was also a new buyer on title, but then there was a 1% or something very low ownership. Have you ever heard of something like that? And if so, what is it that they were trying to accomplish, or what was it that they were trying to mitigate in a situation like that?
The idea is to mitigate the due on sale, right? And deal with all the other kind of ancillary impacts. The lender could still foreclose. Even if the seller kept a 1%, even if they kept a 50% interest, the lender could still foreclose. But they're less likely to. I think that is true. The lender is still going to look at the underlying circumstances, what's going on, are they getting their payments, all of those kinds of things are going to go into that analysis. But you haven't sold the whole thing. If you gift the property, right, there's a difference between selling, right? We have family transfers and all that. But if you look at conventional financing, Fannie or Freddie, even 1% transfer is technically a sale, right? So there's very limited exceptions. You can transfer to your spouse and generally not trigger due on sale as long as the payments are being provided. And you can transfer to your trust, right? Because technically, even transferring to your trust triggers the due on sale clause. But Fannie and Freddie underwriting guidelines say they won't trigger foreclosure in that situation as long as the payments and all the other terms of the loan are being satisfied. So I think it would minimize the chance of foreclosure, but it doesn't eliminate it by any means. And then we still got to get that seller off. So there still has to be a plan to get them off at some point. So my recommendation, if we were going to do that, is have the seller sign a deed for whatever percentage they're saying on now and hold it in escrow. Because what if the seller gets hit by a bus, right? And now they're nowhere to, they're not available to sign. And now there's heirs who might make claims and try to dispute the contract, all that kind of stuff. So you've maybe mitigated the risk of foreclosure, but you've added the risk of how we're getting the seller off later and the seller's judgments still being potentially able to attach to the property.
Now, you mentioned something now. You said potentially transferring to a trust doesn't trigger the due on sale clause. Could somebody transfer a property to a trust and then sell interest in that trust, or make somebody a beneficiary? And would that would there be any risk of judgment creditors? And this is just kind of me.
This
thinking about this in a different way.
People are try to think out of the box all the time. So I actually heard of a real estate brokerage down in, I think they're in North Orange County, South LA, and they're trying to do, and they're doing, this is a brokerage, and they're doing transactions where they're asking the seller to put the property in trust and make the buyers the beneficiary of the trust, because they're trying to avoid reassessment of property taxes under Prop 13, right? So California, we have a system under Prop 13 where once you buy a property, they are only allowed to reassess you up to 2% a year, right? So no matter how much the market's going up, your property taxes are limited to 2% a year. But there are what are called triggering events that trigger a reassessment. One is a sale. So if I sell a property, they're going to reassess it based upon what the current market value is, not the market value when the seller bought the property. So they're trying to cheat the reassessment. That's called fraud. That's a crime. So don't do that. So that I would not encourage trying to do some, like, I get the idea, but there's things like putting it in an LLC, right? An LLC can allow you to mitigate and manage some of this stuff. An LLC that is owned by the seller might not trigger the due on sale clause, right? It's a maybe, it could, and then they could change the members of the LLC potentially. And so there are ways, and there's more creative attorneys than I who will do some of these things. So again, these are all strategies that people can consider. I'm a do it clean type of gal, but there are plenty of people who will try a lot of different things to manage and mitigate.
So in other ways, if you're considering doing one of these transactions, one of the best things that you could probably do is talk to a good attorney that will let you know, hey, look, what you're doing is fraud. Don't do that. Because sometimes a party may not know, like, hey, look, I'm like, I'm not supposed to be doing this. Or, and talking to somebody that can almost just guide you and say, hey, look, if you do it this way, these are the risks. If you do it that way, these are the risks. And then
Right.
you can determine like which risk you're more comfortable with and whether it's something that you want to do. Now, let's say in a scenario where there isn't a servicer involved and you're giving the payment to the seller, and then the seller's making the payment to the bank, but then the seller, you find out that had a couple of unexpected expenses and has been using the money that you've been giving him to make the payment. And instead
Yep.
of making the payment to the seller, has been using it for Chumash Casino. I'm
Yep.
kidding. What would happen in a situation like that?
Well, the loan will go into default, right? It'll get into foreclosure because of non-payment, not because of
Yeah.
the due on sale clause, right? And the buyer will likely find out when the notice of default is
Mhm.
recorded. We're 4 months in by then, right? So we're well into foreclosure at that point, and now the buyer we may have to cover that shortage to keep the loan from getting foreclosed upon. Now, the seller's in breach, right? So the seller has breached. The buyer can get damages from the seller, but that's not going to solve their problem in resolving the foreclosure issue. They're going to have to make the lender whole, or the lender's going to proceed with their foreclosure.
This is from a seller's perspective. So let's say that I'm a seller and now somebody else is supposed to be making my payment. And I'm concerned that if that person doesn't make the payment, then at that point my credit will go down. Is there a way that as a seller, can I ask the buyer to, at closing of escrow, to leave $10,000 in escrow account and for the payment to be made from that account? And every month the payment comes from there. And if the account ever goes less than 10,000, that I get notified that the account went less than 10,000 because it means something fishy is going on.
It's possible to set up something like that. We do it with rent. We do it with a lot of different things
Mhm.
depending upon the circumstances. From a practical standpoint, it's going to be a challenge because the
Mhm.
people who need to get a wrap aren't generally going to be cash rich
Mhm.
and have the resources to do these types of things, right? So it's, again, what can we each make work? If you're that risk averse, right, where you're
Mhm.
worried about them making the payment, I wouldn't do the deal at all. Now, not doesn't mean don't have a safety net, right? There are ways to set up safety nets, but again, if you're really that worried, I'm not sure we want to move
Yeah.
forward.
Anything else that you think that would be important for our viewers as it relates to wraparound mortgages? Any final words that you think would be helpful?
I definitely do think getting good advice makes sense.
Mhm.
And because like you can tell just in this discussion, there's a fine line between what's legal but dangerous, versus what's illegal or criminal, even in some cases. So, and your escrow officer, your title officer, right, those people, they're not lawyers. That is not their job or skill set. They're not in a position to advise you on that. They're going to take your instructions and do the deal the way you've asked them to. So the more that you can get good guidance on what you can and can't do, the better, so that you're not taking unreasonable risk.
So if somebody
Yep.
is looking for a great attorney like you, what is the best way for them to find you?
We're online, right? Our website is relawapc.com. I'm on social, right? So Facebook, Instagram, LinkedIn, any of those social platforms, you can find myself or our firm. We're very active in all of those avenues, and feel free to reach out, and we'll talk and see if we can help.
Thank you so much, Jennifer. I enjoyed this podcast. I enjoyed learning about it. For our viewers out there, if you've enjoyed this episode of the Morales Group Show, please make sure to hit that subscribe button. And if you feel that this episode will be helpful to any friends, family, make sure to hit that share button and send it to them. Once again, Jose Luis Morales, host of the Morales Group Show. Jennifer Felten, she explained to us what wraparound mortgages were and what are the pros and cons of using wraparound mortgages. If you haven't heard this term, it may be more common right now with the interest rates going up, and it may be something that may be circling back. Best advice, talk to a good attorney.